This is a second anticipatory waiver. So all pleadings have been completed.
There is already a notice.
नोटिस है कंटेम्प्ट होगा
45 number.
नोटिस नहीं देखते हैं क्या? Yes.
One item number 39, Your Lordship, I may be permitted to.
39. What is it?
Your Lordship, it's a contempt. Reason order has been passed.
Item number 39. The learned counsel for the petitioner does not want to press this contempt petition, submitting that the reason order has
And
already
we
been
are
passed.
challenged that in fact.
Considering the submissions, this petition is dismissed as not pressed. The contempt proceedings are dropped.
Leadership serial number 44.
You give the serial number and the your appearance.
Yes.
Leadership serial number 44 from the it's a CRMP for restoration of a criminal revenue.
There is no urgency.
The petitioner is in custody.
He will remain in custody.
Lordship, serial number 41, it is for the restoration of criminal.
No, restoration is not an urgent matter.
The law could have proceeded with the criminal.
They will proceed. It's a restoration application. No? You were not diligent.
From supplementary list and writing for mediation for the nationwide 2.0 item 2 second appeal 197 of 2010.
Sorry?
It may not go to mediation.
Okay. Where is the substantial question of law? Where is the substantial question of law? Which order? By which order the substantial question of law was framed? It's on adoption. It is on adoption. Okay. We'll post it for Monday. Final disposal.
Anyway, but Monday, Your Lordship, my senior will argue this evening.
Wednesday.
Your Lordship, if it may come next week, because Your Lordship, Mr. Kalla was engaged in this matter, we do not have the Wakalatnama, Your Lordship, in this matter.
But I'm absolutely clueless. He can't even do the private
No, Your
matters.
Lordship, the additional Solicitor General is barred to do any kind of private practice, Your Lordship. Therefore, just
When do you want?
next week, Your
Choose your date, madam.
Yes. In the 17th, 18th, Your Lordship.
Okay. The counsel for the respondent has submitted that the matter may not be sent for mediation. The counsel for the parties jointly submit that. Otherwise, the case is ready for disposal. Right? Post this case for final disposal on 18th. Okay. The parties to prepare short synopsis and also furnish the copies of the judgment which they seek to rely upon much prior to the next date of hearing.
Item 3 second appeal 214 of 2010.
Yes? It's a part third matter. It was heard in part way back on 12/4/2019. And thereafter the bench must have changed. What is the substantial question of law?
17/1/19.
It's a small substantial question of law. कब करेंगे?
इसको एक बार पीरियड
ये तो मीडिएशन के लिए तैयार होंगे तब ना?
एक बार पीरियड
With the consent of the learned counsel for the parties, let this matter be placed for mediation. the parties to appear before the secretary, before Jhalsa on 16th of February 2026 at 11 a.m. It will be open to them to join online. Okay, 23rd. Right? You can join online. Let this order be, कल कुछ orders किए हैं. This order has to be communicated to the Secretary Jhalsa to ensure that a mediator is appointed for the purposes of mediation. Put this case immediately upon receipt of the mediation report.
From the daily list, under heading for orders with effect, item 3, contempt civil 12357 of 2024, filing number.
Time till 20th February is granted to the petitioner to remove the surviving defects priority. If the defects are removed within time, post on 27.
Item 4, contempt civil 1011 2025.
Ignore this defect as this is a legally aided matter evaluation. The only defect that is standing is in the
This is
matter
a,
legally aided matter evaluation.
you have been appointed by legal aid.
Richard, I have not been appointed. Soumya Pandey has been appointed. She is on maternity leave, so she has started me to.
So what is the defect?
Richard, that the petition has not been affidavit. So as per the notification 525.
Where is the letter showing that this matter has been given to you through legal aid?
Richard, it is in the paragraph I do not have the fine mention because she is on maternity leave. But it is there also, I checked in the morning.
Please let me know. That letter has to be there, no?
Even
You ignored this defect.
Yeah.
Please point it out. इनको दीजिए क्या?
Item 5, contempt civil 5795 of 2025.
Same order.
Item 6, sorry. Under heading for admission, item 31, contempt civil 650 of 2025.
Contempt civil 650 of 2025.
Had affidavit dated 15/1/2026. He has not been appointed.
The learned counsel for the, nobody appears on behalf of the on behalf of the petitioner. Counsel for the opposite party submits that order passed by this court has been complied and an appointment letter has already been issued to the petitioner which is dated 10/1/2026 and is annexed with as annexure A to the supplementary show cause. It's in order. There is no problem, I suppose. I trust you for that. The order having been complied and the redress, the grievance of the petitioner appears to have been redressed. Okay, na?
Yes.
This court does not choose to proceed further in this contempt proceedings. It is hereby dropped. Petitioner का appearance record करें.
Item 32, contempt civil 745 of 2025.
Yes. Petitioner,
Not the last opinion, the state was directed to seek instruction with respect to the approval of the cases. I'm appealing to the university.
yes. State, where is state? Pass over at 2:15.
Just
At 2:15, come at 2:15. Next.
Item 33, contempt civil 1002 of 2025.
Yes, madam.
Your Lordship, in this case, LPA has been filed, Your Lordship, and LPA was taken on 19/1/2026, and condolation of for delay of condolation which has been allowed, Your Lordship. It was fixed for 2nd of February, but could not be taken up, Your Lordship. And the next date is 23rd March, Your Lordship.
Contempt civil 1002 of 25. Nobody appears on behalf of the petitioner. Counsel for the opposite party submits that next date in the LPA is
Yes,
opposite party.
yes,
Opposite party submits that the next date fixed in the LPA is 23rd of March.
yes, Your Lordship.
Pose this case on 30th of April or any other date. Pose this case on 30th of April. Please April को रखते हैं. Yeah, 1st of May. This is a Friday.
Applies.
Yes, could you get that?
in addition to the letter which has appointed Soumya Pandey as delegated is annexed to the leadership, the first one is the leadership. And as per notification 5 of leadership, it should be.
Filing contains civil number 1011 of 25. The learned counsel for the petitioner has submitted that the case has been filed through the counsel upon being appointed by Jharkhand High Court Legal Services Committee. The counsel refers to notification number
5 of 525 leadership.
notification number 5 of 2025 and has submitted that the affidavit need not be filed. Considering the submissions, he submits that the defect regarding affidavit, which is defect number 253, be ignored. Considering the submissions, the defect number 253 is ignored for the time. It's a contempt matter.
Is Indian leadership.
Yes. I got it. Counsel for the state prays for time to seek instructions from opposite party number 2. ये सिविल सर्जन है सदर हॉस्पिटल हजारीबाग to seek instructions and file shows / compliance. कितना टाइम चाहिए?
For your leadership, it is only party number 4, civil surgeon number party number 4.
Opposite party number 2. Post on 27th February.
Item 34, Contempt Civil 1336 of 2025.
Petitioner is absent. However, as per office note, the notice upon OP number 2 has not been served. Let the notice be issued to the opposite party number 2 through concerned police station, for which requisite be filed by the petitioner within a period of 1 week. Since the petitioner is absent, let a soft copy of this order be forwarded to the council for the petitioner for compliance. Post on 27th.
Item 35, Contempt Civil 1340 of 2025.
Yes.
The last occasion that is on 11th of December 25. Respondents were directed to file show cause.
You have made all the persons as opposite parties. So yes,
And the contender is respondent number 5. We listed so order only said that respondents are directed to comply with the elect order to give promotion to me right from the date on which the juniors were given. So because action was upon the state, I gave a representation to the district superintendent of education, and thereafter no action was taken.
so the action has to be taken by DSP.
Yes. In case he doesn't do his duty, then he is secretary.
Content case civil number 1340 of 2025. The learned counsel for the petitioner has submitted that in spite of order dated 12/12/2025, the show cause / compliance report has not been filed. He submits that the case was being represented by the state council and the contender has been made party by name, and therefore notice may be issued to opposite party number 5, before whom the representation was filed as contained in Annexure 3/1. Let notice be issued to the opposite party number 5 as to why a contempt proceedings be not initiated against him on account of willful and deliberate non-compliance of the order dated 27/4/2022 passed in WPS number 7065 of 2013. The requisite for notice be filed within a period of 1 week.
Through ordinary process.
State का absence लिखा है.
Through ordinary process.
Police station.
Police.
कंटेम्नर को पुलिस स्टेशन से नोटिस चाहिए। कम से कम एक पुलिस वाला बंदा तो पहुंचेगा। अभी तक तो ये बोले नहीं है कि विटनेस के सामने पर्सनली रिसीव कराना है। अच्छा लगेगा? अभी नहीं बोल रहे हैं इसलिए। नहीं तो यहाँ तो विटनेस के सामने पर्सनली रिसीव कराने का भी सिस्टम है।
कुछ नहीं होता है वैसा।
हो जाएगा। आप चिंता मत कीजिए, कंप्लायंस तो हो ही जाएगा।
Yes, we are interested.
पोस्ट ऑन 27
Just 1 week में file करें।
1 वीक 13 तक रिक्विजिट फाइल करिए, 27 तक आ जाएगा।
Item 36 contains Civil 1345 of 2025.
मोस्ट इफेक्टिव नोटिस। यस प्लीज बताइए क्या हुआ आपको?
पार्टली कंप्लाइंट हुआ है। इस पैसा मिला, चार्जर स्वतः था जिनका 5 लाख समथिंग की आधा कर दिया। अभी आ गया कि 4 लाख के तो मिला, अच्छा लगा।
तो जो भी रिमेनिंग है ना, उसका आपको ग्रीवेंस के लिए हम आपको दे देते हैं लिबर्टी।
एफिडेविट है सर, तो पहला एफिडेविट दिए,
क्या दिया हम?
उसमें लिखा है कि 5 लाख से बनता है।
अभी कितना पेमेंट किया आपको?
ये है आपको 4,39,920।
922। ये क्या सैलरी का पेमेंट है? क्या चीज का पेमेंट?
हाँ, कितना सैलरी?
सैलरी तो टीडीएस काटा होगा आपका सैलरी हेड में।
काटे नहीं।
कैसे नहीं काटे होंगे?
ये स्केल नहीं मिला था, स्केल नहीं मिला था।
जो भी है स्केल नहीं कि बिना टीडीएस काटे का ही पेमेंट होता है। सरकार का अपना नियम है। तो दे दिए हैं वो।
एडमिट पारा पे होता एडमिट बोले कि मिला है 5 बजे।
आपको कैलकुलेशन चार्ट भी दे दिए हैं, सब दे दिए हैं आपको। इसमें जो भी डिस्प्यूट करना है आप तक करते रहिए। सब कुछ
कुछ चार्ट लगाया हमने पास।
हाँ
7 लाख 13 लाख समथिंग में डील बनता था, हमने लगाया पेज 30
पेज नंबर 27 में लगाया है ना?
पेज 44 हमने लगाया है।
पेज
44
44 of the show cause।
माइक हमने लगाया 30 लाख 38
पेज 44। ये क्या है? ये क्या चीज है?
ये एप्लीकेशन था पेज 43 में हमारी माइक न्यूज़।
ये जो 15% वार्षिक ब्याज पर चक्रवर्ती ब्याज,
कितना लिखा है काटेगा देखिए पेज 45 में प्रिंसिपल अमाउंट 30,38,971 ये इंटरेस्ट ही सब
इंटरेस्ट इज 59 lakhs। आपका तो लिटिगेंट फिगर ही देख के खुश हो गया।
तब नहीं जाएगा भाई प्रिंसिपल जाएगा काटेगा आई तो खाली एफिडेविट देख के सब पारा 5 देख लीजिए ये में लिखा है पारा पे कुछ एडमिशन है कि 5 लाख 41.5 इंस्टीट्यूट के लाइसेंस है
कहाँ है उनका एडमिशन दिखाइए।
खाली हम उसके लगा नहीं पाएंगे मेरा एफिडेविट
अब उसका हम क्या करें?
है
इतना टाइम क्यों वेस्ट करना है? एफिडेविट फाइल करिए। Contempt Civil 1345 of 2025. Counsel for the petitioner seeks adjournment. Vote on next Friday, 13th.
Item 37 contains Civil 1402 of 2025.
Yes.
We are compliant. And all the payment details are annexed to page 9.
Page number?
Page 9 of compliance certificate.
This is the calculation.
Yes.
Remitted. Payment दिखाइए. Show me that it has been paid.
Where my statements not
Statement से नहीं चलेगा ना. Show me that it has been remitted to the petitioner. Has been called upon to rectify his claim application and submit requisite document. What is Annexure C? What is Annexure C?
related to pension and benefits.
The petitioner को बुलाइए. 2:15 बजे आइए. We'll fix a date for his appearance before the authority to do the compliance. We'll ensure that 34 lakhs उसके account में चले जाना चाहिए during the pendency of this contempt petition. होली के पहले. ठीक?
Item 38, contempt civil 1439 of 2035.
Yes, please. Comply.
Now the implementation of the order, I want to say, and you can see that
Let us see the order.
yes, the order which has been passed by on 13/10/2022, page 15 to 36. Main point 11 point which has been decided by this court, by this honorable court, that is page paragraph 31, and then 32 is the direction. 31 is 54.
Thirty-one.
31 is 54. The case was that they had a reserve candidate, but there is no reservation in the posting room, but there is a procedure to give the mark relaxation. So for the SC, SB, OBC, they will get eligible 52%, and the general was 60%. Your lordship held that they are entitled for consideration against the general quota, but giving the marks relaxation, and that is paragraph 31. Can you see that?
This order was not challenged.
And after that they have been directed, if the sanction post is there, they have to they are entitled to the benefit. They should give the benefit, that is 33, and within 3 months they will pass that order. That order is final dated 13/10/2022. Now after 3 years 2 months they have passed an order. Can you see that? What is the order? They have done the same thing, no relaxation has been given, and they say the post has been surrendered. Paragraph 8. They have quoted the last portion of the order at paragraph 6. Kindly see that. After that, what is the consideration? Paragraph 6, page 5. It is only stated and submitted that the WPS number was heard by the Honorable Court, and after hearing the parties, the Honorable Court has been released to dispose of the with the following observation. As per learned counsel for the state, the entire selection process is over, but the learned circumstances have submitted that the post are still vacant. Respondents are directed to evaluate the petitioner as per recruitment rule, and if the petitioner satisfy other criteria as per the advertisement rules and circular, etc., and are found to have been obtained marks more than the last selected candidates under general category, and if the vacancy is available, the respondents are directed to consider the case of the petitioner for appointment against the vacant post. The needful is to be done by the respondents within number 3 within period of 3 months from the date of communication of this order. The order is required to be communicated such and such with the petition, and what they have stated matter can consider. In between the period they have filed the LPA, and LPA was dismissed for default on December 2024, and now they have passed on 3rd December. Paragraph 8 is the reply. That it is real. Page 8. It is stated and submitted that in compliance of the order dated 13/10/2022 passed by the Honorable Court, is representation of the petitioner have been considered on the basis of the advertisement, rule, circular, and availability of the vacancy under general category, and considering the same, legal reason order has been passed by memos in such and such. They have not narrated, therefore I want to place an Annexure A. Annexure A is page 15. What they have passed. As per the that has been quoted.
They were supposed to give the
Marks relaxation. And
they were
also-
supposed to give the marks relaxation and appointment if the vacancy is available.
Because yes, now they say, my lord,
If the vacancy is not available,
no. Now what they have said, that vacancy has been surrendered on such and such day. That is before the judgment. Whether they have
surrendered.
Yes,
When?
they that is the last page. When you see the last page of the improved order, page 18.
Page 18.
Yes. स्कूली शिक्षा एवं साक्षरता विभाग झारखंड सरकार द्वारा उप निकट झारखंड प्रारंभिक शिक्षक नियमावली 2012 का समाप्त करते हुए अधिसूचना 1060 दिनांक 7/6/2022 के द्वारा झारखंड प्रारंभिक विद्यालय शायद अटैच बर्ड नियमावली 2022 की लागू की। Therefore, if that order has been passed, then maybe the notification has been changed, but they should have passed, they should move before this court for modification of the order of whatever may be. But now they say that we have not getting 60%. That means the direction which has been passed by your lordship that has not been implemented. At page 17. They said they are उन लोग का 60% से कम मिला है. That was the dispute, and that was struck down by this honorable court. That has not been modified. How they can say I is the chart? What marks has been given to me? Whether that I am taking.
Where is this notification?
That is not a reconciliation.
Why have you not brought? First, tell me one thing. You at the outset said that the order has been completed. Is it a compliance of order?
The leadership, the operative part of the order states that if there is a vacancy available, then the petitioner, if they are found to be in compliance with the rules and circulars, their appointment needs to be given to them. But after on 7th,
Your order is again referring to the cutoff marks, 60%. All these things are also there in the order. And you say that the vacancy has been surrendered.
a new post has been created as per the new rules.
So where is this circular? And if that was so, why was it not brought to the notice of this court at the stage of writ petition? Writ petition has been disposed of on 13/10/2022. Why didn't you bring it on record? And you have wasted so much of time of the court. You should have straight away said that the writ has become infructuous. Now we have new post and new vacancies, new policy, whatever it is. Why didn't you bring it on record? Yes?
That is the leadership,
Where is this notification?
will read it. Last just we will bring that notification on the by filing. The vacant posts that were vacant, those were transformed into a new post, Sayak Achar. That is said in the last paragraph of the lecture here. इससे स्पष्ट है कि सहायक शिक्षक का सभी दिक्कत पर विभाग द्वारा कार्मिक प्रशासनिक एवं राजभाषा विभाग झारखंड सरकार को समर्पित कर देने के पश्चात तथा सहायक शिक्षक का कोई पद रिक्त नहीं होने के कारण वाकिले का दावा अमान्य करते हुए
Who was the authority who was supposed to pass the order?
DSC.
president.
Deputy surrender and where is the marks there? Page 17 they have said they were not obtained 60 marks, 60% marks which is required. Then the eligibility portion is also there not right. And where is the marks?
The marks may not be relevant if they have actually, there is no vacancy because it was submitted by you that the vacancy is still there.
Yes, vacancy was there. Because
No, vacancy was there.
That is
What he is saying is that the vacancy was not there on the date. On the date the judgment was passed on 13/10/2022, The entire post was already surrendered by virtue of a previous notification.
Yes, madam, kindly consider if that was brought to the notice of this honorable.
You see, madam, you had made an oral statement that the vacancy is still there.
Madam, kindly consider, they have surrendered, that is admitted, therefore post was there. That is fact, post was there. What was
They
the-
had surrendered prior to the order of the writ court.
Prior to the order.
Yes.
Why they have not brought to the notice?
No,
of
the
order?
point is that at the final portion of the order, you had said that vacancy is still there. So there was no occasion for them to really verify what is the vacancy position, whether it has been surrendered, not surrendered. They were contesting the case on merits.
Madam, kindly consider, when the judgment and that has been hard day by day and your lordships also passed that order very specific.
You see, had this surrender, and it's a notification, it is not just a letter.
Yes, madam, if it is by notification has been surrendered, it was brought to the notice of the this honorable court, then order may be passed that they should be adjusted against that post,
Which post?
against the which post has been surrendered. Post is there, post has been surrendered because by virtue of the new law. Then it may be ordered by your lordship that they may adjust it against that post. Post is there, it has been transferred from A to B, that is the position. If B is competing, now virtue of the that act, they on the date of the judgment that position has been changed.
Madam, the point is that this part of the matter cannot be decided in a contempt proceedings. If you say that your relief will relate back to the date of filing of the writ petition, and in the meantime, if they surrender the post,
What is not.
so
no.
therefore,
But another
so therefore, the order was passed on 13/10/22, and
Yes.
prior to that date, the post was already surrendered. Then
Yes.
how can you say that there was vacancy on the date when the order was
My
passed?
lord, kindly consider, that was in the dark, they have not said so, I have also not knowledge for that.
Madam, you see, the council, the council may not have personal knowledge.
Yes.
So you also may not have personal knowledge.
I say
But,
that.
but
I
this
say
order
that.
was passed on the basis of your submission that the vacancy is still there. Naturally, you did not have any knowledge that these vacancies have been surrendered.
My lord, my submission is this, what was the difficulty when they came to know, because I have given the writ petition and the copy, whatever was directed to say, that has been given in the year 2022.
That's right.
What was the difficulty to say them before this honorable court that the order has no effect and
That's
what?
even if they have not done the needful.
What is the position? The judgment is no value.
It becomes no value because all the facts have not been brought to the notice of
My
this
lord,
court.
kindly consider, the post is there, that was my submission. Your lordship is correct to say that was not my knowledge, maybe that was not in their knowledge also. But when the representation has been given, that was the deadline was that within such period that will be finalized. They are sitting tight over the 3 years and 2 months. Now they have said that they by virtue of the notification, it has been handed.
You see, you file an affidavit annexing the notification and produce the file regarding issuance of notification.
Yes.
Original file.
Yes.
I want the original file as to when did it move and how did it move. Okay?
And one point, if
You
you
do.
kindly
The-
consider
just a moment.
60% forward. When that is the,
That is irrelevant. We'll see that later.
they have said. they
Contempt Civil 1439 of 2022. The counsel for the opposite party has submitted that the order has been complied, and as per the recent order, the post was surrendered by notification number 1060 dated 7/6/2022. The said notification has not been placed on record. Further, the said notification was not placed on record before this court in the writ petition filed in the year 2014 and disposed of on 13/10/2022. Counsel for the opposite party is directed to place the notification on record along with the original file on the basis of which this notification has been issued. How much time do you need? Post on 20th. The affidavit, ठीक है उसमें. The affidavit should be filed by 18th. You annex that document. Yes, and then the record will be produced on 20th.
Another point also they have discussed, 60%.
We'll see that. We'll see that later.
They have said not
We'll see that later.
much.
Item 45, KBA 50.06 of 2023.
They were directed to file some contract.
Yes.
Have they filed it? Yes, please.
Yes. What was the order passed by your lordship and then what is the change of circumstance? Let's try to just highlight it. Your lordship's orders and actions were based on it.
All these sections are there in which you have been made accused.
Okay.
All these sections are there in which you have been made accused. Which section has got the highest punishment?
387. 387. Although there is no such, I mean, that is there is a separate issue.
Are you named
Yes,
direct allegation?
there are. The allegations that yes, I was also part of the mob.
You were leading the mob.
Yes, I mean, now, perhaps, till that period, there was no issuance of notice against me. There was a COVID period. When this order was passed, there was a direction to surrender.
COVID period expired when?
But it's expired 2020.
March.
Not till that, yes, still that,
It is order dated 31/5/21.
yes.
So it
No.
was not COVID period.
No, it was. I think if you also would see.
Give me the exact COVID period.
Video conferencing. Let us leave aside that COVID period. Now, your lordship comes to election 3 at page 31. When this notice is served, when I am required to reply regarding the allegations in the affair. Till today also there is no word against me. This was so I personally appear before the investigating officer and give my reply, which is election report. Please. I personally appear, give my explanation as to what exactly had happened. Now, what is the subsequent order passed by one of the coordinate bench? If somebody has appeared, then what the court passes upon? This is what in Section 5 at least. May I read that order?
Appeared pursuant to notice under section 35(3).
That is 41 or 35 is one and the same.
It's one and the same.
Yes, it's 41.
Two sections are same in BSNL. I have not seen. ये दिखाई सर ये
41 age.
DNSS.
41 age.
अभी हम क्रिमिनल मैटर्स नहीं कर रहे ना, नया एक्ट के बारे में हमको ज्यादा आइडिया
देखो, हम बता 41 एक पुराना सीआरपीसी का है, उसी का करस्पॉन्डिंग सेक्शन जो हुआ था देख पहले 41 देख लीजिए क्योंकि ये that time BNS was not
Yes, Council.
In this case,
You have no objection?
No, madam.
You have not filed your contract.
No, we need to
You never prayed for an adjournment. I'll impose heavy cost on you. You are walking in, are you walking in the drawing room?
file code 6.
Then?
Code 6.
कोई तो आपका तो इतना बड़ा टीम होना चाहिए जूनियर्स का.
Obviously, यहाँ 2 लोग नहीं आए हैं medical analyst.
क्यों नहीं आप कॉन्ट्रैक्ट?
Allowed in short formation.
किनसे आप इंस्ट्रक्शन ले रहे हैं कॉन्ट्रैक्ट फाइल करने के लिए?
No, we directly take it from
From whom?
the SP office.
SP office, no? If he does not have, if your counter affidavit is not filed, SP will come and assist this court.
No, I'll assist, madam.
You have no regards. कल ही सुप्रीम कोर्ट का जजमेंट हुआ है कि यहाँ पे एंटिसिपेटरी बेल और बेल सब पेंडिंग है. It's for you.
Definitely.
Then?
I'll coordinate both on the Sindri PS as well as the SP office. I'll get it later. Just a short information.
You see, this person, you also have to explain. This person is direct accused. He was leading the mob, which led to the incident.
Definitely.
What were you doing?
We should have.
2021 से लेके 2025 तक. What were you doing?
We need to explain that.
He is a political person. He will take the government for a ride.
No criminal antecedent, no criminal antecedent.
Political person should have a criminal antecedent.
They should have a criminal antecedent.
They should.
Such a
I have no idea about it.
Such a good thing. He's got no.
It's a good thing that the political person. No.
Situation.
Yes, Mr. Counsel, I am telling you this. It is something which is very, very serious. There was a direction to surrender in 2021. He did not surrender. He's an accused of Section 307 IPC. Right? You don't do anything to arrest him. You don't take any steps against him. Why don't you acquit him? Don't submit charge sheet against him.
Procurement of sand was the issue. There's a whole village where there's a bread and butter issue, and then nobody got hurt. See, they got angry because of the fact that during COVID period, the mob came out and there was they thought that this would lead to spreading
Mr.
of
Sailesh,
COVID.
I am telling
Yeah,
you,
yeah.
I am not inclined to grant you anticipatory
Yeah,
bail
your lordship may not
because my
Your lordship may not
order
be.
by which you were directed to surrender has not been complied.
That's a peculiarity of the circumstance.
We do not know
that
what
there was a
peculiarity.
court.
When there is
I
a
asked
direction,
him.
when there is a direction,
I asked him.
you should have come and got the order modified that there should not be any direction to surrender. No, not mistake.
But that would not.
It is not a mistake. My direction is not a mistake.
We are here.
Mr. Sailesh, my direction is not a mistake. You cannot say that my direction is a mistake.
No, mistake on our part. So I am saying mistake on our part.
It is not an.
But your lordship would say that
The matter is quite serious, Mr. Sailesh. We will not take it like that.
It's a liberty. It's a question of liberty. Similarly situated.
Liberty
co-accused
misused.
persons- Liberty. Similarly situated co-accused persons have been allowed bail on the ground. That look here, there was a notice issued to them and they appeared. So there is no question of apprehension. Your lordship. And
you ask me, you file a petition to place it before the same bench.
why
Place it
should
before
I?
them.
I
You
mean,
should.
did I say that I am afraid of rejection? Why should Bharat sir, if your lordship?
You see, I am not inclined, I am making it very, very clear to you. I am
I-
just waiting for their response as to what have they done from 2021 till 2026.
I'm just raising my case. I'm just trying to hit upon your lordship's concerns. Do I get that much of chance? I'm not saying, I'm not asking for it. I'm just trying to see. This is a situation of peculiar situation. And a person.
Let him file his counter affidavit because everything is required to
I
be.
just asked.
ABA number 5066 of 2025. No counter affidavit has been filed in the incident case in spite of the last order. This court is unable to understand as to what the authorities of the state were doing.
But this particular aspect will harm. See, it is a domain, which is investigation is a domain of the police.
That's
Your
right.
lordship pass
They
it.
can
Lordship just- but
rise from the slumber anytime they want.
I just give my lordship.
You file a counter.
Yes. that's-
Let the counter affidavit be filed latest by 12th of February.
Yes, sir.
Post on 30th.
Was currently on 15th.
एक दिन में ही एडजर्न करेंगे. आप answerable होंगे सुप्रीम कोर्ट.
12 कर दीजिए.
12
12 कर दीजिए 13th. एक दिन का.
13 नंबर थोड़ा सा वो होता है
उसके लिए नहीं. थोड़ा सा
However, the counsel for the petitioner has submitted that the matter may be posted on 20th. Post on 20th.
फरवरी तो उसके बाद. अच्छा आपका अगर है तो हम तो आपसे लड़ने.
हम तो कुछ नहीं बोल रहे, हम लड़ाई की भी बात नहीं कर रहे. आपको जब बोलिए 2027, 28
थोड़ा पहले ही रखते.
2 साल बोलेंगे उसमें रख देंगे.
थोड़ा पहले ही रखते. 14
14 को भी सैटरडे.
नहीं, फ्राइडे के अलावा कोई और दिन नहीं.
अच्छा फ्राइडे 20 को.
20 को.
काउंटर एफिडेविट का तो 12 तक ही रहेगा ना.
हाँ, काउंटर एफिडेविट 12 तक आपको फाइल करना है.
From supplementary list, under heading for admission, item 1, CNT 111/2026.
The reason for filing this case is that it arises out of a contempt case. In the writ petition, this honorable court directed for payment of the arrears of the due to the original petitioners for the period from 99 to 2002. Then they filed the appeal, inter-court appeal, LP. So in the contempt application, this honorable court directed the opposite parties to deposit the amount before the learned registrar. It was
Appeal,
deposited.
what happened in the
Now after the disposal of this, we have not been given the amount by the learned registrar.
LP has been dismissed.
Yes, and thereafter the contempt was disposed of. It kindly sees the order dated at page 42.
Then this amount was deposited.
Yes, deposited. It is deposited. It is lying before the registry of this court, but we have not been given the amount by the registry.
On what ground?
On one of the ground which we have been told that one original petitioner who was substituted in the writ petitioner, there is no order who will get the amount, in what manner. So we have stated in this modification petition that the widow may be given, the sons have no objection. Widow may be given, the sons have no objection. So
There is no objection. All the sons have filed affidavit here.
one son has filed affidavit. One son has filed affidavit. And remaining petitioners, there is no information. The remaining petitioners, we were told that the amount will be deposited. But we do not know, despite that the amount has not been deposited in the account of the remaining petitioners. And they are all old persons, retired long ago.
No, I do not know. Their amount was deposited in the registry.
Yes. Now it was to be credited from the.
So did you go to the registry?
Yes.
Where is your letter? Where is your request?
Yes, we have submitted an application.
Where is that application?
We have submitted an application. We have stated
Where is that application which you have submitted?
that application is not on record because they deposited it. They have submitted it before the registry.
Where is that application?
That copy they did not kindly maintain.
Page number 38 is what?
That we have submitted. नहीं वो तो dispute ही नहीं है. वो तो
तो
जमा-
डिस्प्यूट नहीं है, इनको डिसबर्स नहीं हो रहा है, लेकिन ये जाएंगे नहीं रजिस्ट्रार जनरल के पास, यहाँ पे आ जाएंगे.
नहीं गए ना.
तो क्या किए हैं? रजिस्ट्रार जनरल हैज बीन मेड पार्टी. Whom do I ask? If you would have said that the amount is not being remitted to you in spite of the order, then we would have done something about it. LP are all disposed of.
That has been taken note in the last order dated 14/11/25. Since the LP was dismissed, therefore this permission was given. नहीं इससे related. Page 42 and 43 order that clarifies it.
So from where do I modify this order? You just tell me. You have not put the necessary documents on record. Whom do I ask? आप जाइए आरजी के पास, उन्हीं के पास जाइए.
Because I thought it not proper to bring it on record. Something
Why
against
should you
the
not bring
registry.
it?
No,
It is not a matter against the registry. They must have something to say.
because
Registry will not have anything against any litigant.
yes,
Right.
But despite that, for 2 long months we waited. Only one objection.
कहाँ से आप बोल रहे हैं?
One objection. They have repeatedly approached. They have even made the Registrar General, everyone, but except for petition number 5, we can understand. Original petition number 5, the substituted years, that there was no order for apportionment. For that we can understand. But remaining 4, there was no reason for not.
But even in your petition, you have not mentioned that you have been approached before the Registrar General. You have not even annexed anything.
Now I am only telling one thing, that if I specify.
I will not issue any fresh.
No, so far as the original petitioner who died, regarding his legal years, to that effect we have made a prayer in this CMP, because that would be one of the reasons for withholding everyone's amount.
How can it be? Everybody has a different claim altogether.
Different claim, different amounts.
Different amount.
But
you must have quantified. You must have given the breakup of each person.
We have stated in this petition also. We have
They
stated
are
in
given
this
different
petition.
in favor of different petitions.
We have stated.
You have submitted by way of DD in the name of the petitioners.
No,
In
in
the
the
name
favor of the Registrar
Registrar
General.
General.
But the amount breakup is different with regard to each petition.
Para 8, we have stated the amount. Page 9, para 8.
We are not bothered about the amount.
Just after the 14/11/2025 order, we have stated that these petitioners have not been paid the amount due to so and so respectively.
So stated what? You have to go there. Go.
We have approached there.
हमको नहीं दिख रहा कहीं. ना कोई statement है, ना कोई document.
And only one thing can be done. Only one thing. That so far as petition number 5 is concerned, in her respect, that the amount, if the amount is credited in account of the widow, since all the legal representatives of the original petition number 5 were made parties in the writ petition by substitution, accordingly they were parties in the contempt case. So all 3 were there, and
Where is there no objection?
we have stated in this
Statement से no objection होता है.
page 10, para 9, we have stated petition number 6 and 7, who are the sons of late Sridhar Singh, have no objection. Page 10, para 9. And the affidavit is sought by one of this, the petition number 7, one of the son.
One of the son of petition number 5.
Yes.
Petitioner number 5, who was substituted in the writ petition?
The writ petition, Sridhar Singh, who was the original petitioner in the writ petition, he died during pendency of the
Petitioner number.
petitioner number 4, Sridhar Singh.
He was substituted by 4 legal years.
3 legal years, widow and 2 sons.
देखिए CMP number 111 of 2026. His petition has been filed for modification of. We are seeking a direction in CMP.
Appropriate order from this honorable court for payment to the petition number 1 to 4.
एक ही बात है ना? The petitioners are seeking a direction for payment of amount to petition number 1 to 4 and petition number 5. This has been filed for the following relief. The Learned Counsel submits that the contempt proceeding was dropped by the order dated 14/11/2025 and so far as contempt case civil number 355 of 2023 is concerned, the same was inter alia filed by the legal heirs of Sridhar Singh, who was petitioner number 4 in the writ petition. He submits that the sons of widow of Sridhar Singh has no objection if the amount is released in favor of his widow, namely Renuka Devi. The learned counsel has submitted that the amount has not been released by the Office of Learned Registrar General in spite of order dated 14/11/2025. However, from the records of this case and the pleadings, it nowhere appears that the petitioners or the legal heirs of Sridhar Singh had approached the Learned Registrar General for release of any amount. Further, it is not in dispute from the side of the opposite party that the amount has already been deposited before the Learned Registrar General. In such circumstances, it is for the petitioners to approach the Registrar General for release of the amount with their due identity. And if the other two sons, if the two sons of Sridhar Singh have no objection for release of the amount in the name of widow of Sridhar Singh, namely Renuka Devi, then an appropriate affidavit to that effect should also be filed before the Registrar General. And if an appropriate affidavit is filed and the Registrar General is otherwise satisfied, the amount relatable to Sridhar Singh be released in favor of Renuka Devi it has been submitted by the Learned Counsel for the petitioner that the LPAs mentioned in paragraph 5 of the order dated 14/11/25 passed in contempt case civil number 795 of 2022 have all been dismissed.
LPA 569, two of the LPAs has been dismissed. One LPA which was against this petitioners, that has been dismissed. LPA 569 of 2023. LPA 570. LPA 570 of 2023.
इसमें 570 का तो नंबर भी नहीं है.
Page 3, para 3 में.
अच्छा ठीक.
Para 3. And that order is on.
And what about LPA 613?
With that we have no concern because these petitioners have not responded to it. That appears to be pending.
Paragraph 5, paragraph 3.
Paragraph.
He submits that the petitioners are seeking the release of the amount as the connected LPA, that is LPA number 569 of 23 and 570 of 2023, have already been dismissed.
That order is on record with this.
And so far as LPA number 613 of 2023 is concerned, the same is still pending. This court is of the view that it is for the petitioners to approach the learned registrar general for the release of the money which has been deposited this petition is disposed of.
See, 8 content matter was put out 46 area. Correct.
Okay.
Item 46. Content is 1 of 2026.
I know the region order, the region order, they are part, but according to my understanding of the region order now, they have not at all considered the Honorable Supreme Court order, pursuant to which they have been directed to take a decision based 26 now of the order.
सुप्रीम कोर्ट के ऑर्डर का कंटेंट यहाँ पे कैसे हो?
नहीं, सुप्रीम कोर्ट का पेज 26 एक बार देखा जाए order का।
Yes. So 86 is the prayer quoted.
And this comes, page number 29 of the region order. We have considered the judgment of the apex court. It's a page 35, madam. Page 35, paragraph 15.
Yes.
Accordingly, this writ petitioner disposed of enabling the petitioner to individually approach respondent number 2 by filing detailed representation with supporting documents, and upon such representation, the respondent number 2, who shall look into the grievances of the petitioner in accordance with law, and also taking into consideration of the judgment passed by the Honorable Patna High Court, which has been affirmed by the Honorable Supreme Court, and also the policy of the state of Jharkhand, including any decision guidelines which might have been taken by the state of Jharkhand. The petitioner directed to notify one set of. Now, they are all just to teach us number, and they are pointing against advertisement 1 of 1987. The counterparts who continue that we have, they have been given.
That's
all the-
right. Those things have been taken care of. They have filed a reasoned order. They have filed a reasoned order, isn't it? If you are agreed by it, you challenge it. You can't do anything about it. In contempt proceedings. क्या करें बताइए? Contempt proceedings में जितना order है उतना ही ना compliance. इसको beyond क्या देखेंगे? If you are agreed by it, you challenge it. I'll give the liberty to you. If you contempt civil, 1 of 2026. The learned counsel for the opposite party has submitted that reasoned order has been passed in terms of the order dated 22/4/2024 passed in WPS number 369 of 2023, which has been placed on record through the show cause. Since the reasoned order has been passed, this court is not inclined to proceed any further in these contempt proceedings. However, liberty is reserved with the petitioner to take steps in connection with the reasoned order as may be permissible under law. This proceeding is stopped.
From the daily list under heading for final disposal, item 1, second appeal 261 of 2017.
Before I start, I will make a very simple request. I will start my argument today. I will make my argument only for the concluding part of the argument. Pray that Mr. Gupta may be given an opportunity of Mr. Rawat.
So you want to pass a time?
No, I'm not saying. To answer their rebuttal, because they will rebut. To answer their rebuttal, I only see on Monday.
I will not adjourn it.
No, no, I'm
We'll
not
start
saying-
it today, we'll finish
Because
it. He can come and give
He is not there
addition.
in meditation. He is not he's out of station from
On the last occasion also he was out of station.
from last 1 week he is not.
But you have not moved any adjournment slip.
Because you
No, we will adjourn it with cost. This is what is this? Quarter to 12 this matter is taken up and you say that for the final conclusion Mr. Rahul Gupta will come. Yes? What kind of submission is this?
because your meditation
We'll adjourn it with cost. Don't worry about it.
I'm not seeking.
If you are not seeking, we'll conclude it today. If you are not seeking adjournment, we will surely conclude it today because lot arguments have already been recorded and I have read the file also.
Then I pray that it will be taken up on Monday.
It will be, but subject to cost, not without cost. You have taken this court too lightly.
No, we are not taking it lightly.
Yes, of course you are taking
Because the
it.
period-
You are taking it too lightly, and in cases where the adjournment request is not circulated, particularly in second appeal and first appeal, the matter is adjourned only upon payment of cost.
I'm only praying for Monday.
Yes, of course on Monday. But who will pay for the 2 hours I spent in reading the file? You must not have even spent half an hour reading the file. I spent 2 hours reading the file in the morning, so you have to pay for it. At the cost of other briefs. When I read one file, I read it at the cost of other briefs. I thought that we'll decide it today, or at least we'll reserve the judgment today. You choose your date. I'll give you a date, but not without cost. Then मंडे देखिए तो हम लोग रखें हम होंगे केस
The second appeal है 131 of 1998 Monday को 10th.
ठीक है मंडे को वो एक मैटर ऑलरेडी फिक्स्ड है उसके बाद आपका केस करेंगे बट सब्जेक्ट टू कॉस्ट नॉट विदाउट कॉस्ट
How much cost?
यू विल सी इट इन द ऑर्डर एसए नंबर 261 ऑफ 2017 आपका एडजर्नमेंट रिक्वेस्ट आया था
जी नहीं no.
द लर्नेड काउंसिल फॉर द पार्टीज आर प्रेजेंट मिस्टर नाम बताइए Mr. Surya Prakash submits that Mr. Rahul Gupta, who is the arguing counsel, is not available, and for concluding arguments, the matter may be placed on Monday. No advance notice seeking adjournment has been circulated. No intimation to seek adjournment in this case has been given to the learned counsel for the respondents. The matter has been taken up at 11:45, and since the matter has been substantially heard on earlier occasion, it was likely that the matter would have been concluded, and if the arguing counsel would be available. Since the petitioner appellant is seeking adjournment and no advance notice seeking adjournment has been circulated, the matter is adjourned at his request for Monday to be taken up after the case which is already fixed at 10:30. इसका नंबर दे देंगे इसका, ठीक है?
जी.
Subject to payment of cost of rupees 10,000.
The leadership 10,000 is way too much.
It's not too much.
I have to bear
It's too
the
less.
cost. I have read
My
the file.
every minute costs 1,000.
Leadership,
You know how much the system is spending on us.
Absolutely.
So every minute costs 1,000.
Leadership,
Please don't waste my time. चलिए, the cost should be deposited by tomorrow. Order तुरंत upload कर दीजिए इसको. Failing this, this appeal shall stand dismissed without listing.
then I'll start my argument. Leadership.
I'll finish it. You complete it. I will not adjourn it. You start it. You are most welcome.
Because he has.
You are most welcome to complete the argument today. It's 11:45. I can finish it by 4 o'clock. You can start and finish.
5,000 maybe. Completely. only on Monday we are seeking only 1 day indulgence.
आपको बोले ना, आप समझ नहीं रहे मेरी बात. आपका फाइल पढ़ने के लिए हम दूसरे फाइल नहीं पढ़े ना. ये क्यों नहीं समझ आ रहा आपको ये बात? एंड यू नो द सिस्टम. यहाँ तो रोज अपीयर करते हैं. आपको किसी ने मना किया था? द फर्स्ट केस ऑन द बोर्ड. Therefore, it appears, you know, I have got an impression by this conduct of yours today that you have taken this court for a right, which I will not accept. एक पैसा कम नहीं होगा. आप please don't disturb me anymore. Call करिए.
May take a short pass over for 2 cases. I will just get the instruction from you.
What instructions?
That shall I continue or make an adjournment?
Continue means what?
I'll start
Continue
my-
and finish.
Absolutely. Absolutely. For 2 cases. Short pass.
ठीक. Call करिए.
Item 2, WPS 3754 of 2.13.
Now you have filed a supplementary affidavit. तो बस फिर उनको रिस्पॉन्स करने दीजिए. फिर हम क्या करेंगे? फिर ये होगा कि बिना काउंटर एफिडेविट का ऑर्डर हो गया तो सप्लीमेंट्री का तो रिप्लाई करना पड़ेगा ना. जो भी तो क्या करें? यू शुड हैव. ये क्यों ऐसा करते हैं आप? प्लीडिंग्स कंप्लीट हो गया, एक सप्लीमेंट्री एफिडेविट लगा दी. Supplementary affidavit, they are bound to respond to it. You want to respond or you don't want to respond?
Certainly. Because that, on that basis the matter was remitted.
Yes, that no counter affidavit. Then again यही होगा कि supplementary affidavit का counter affidavit नहीं आया. I don't want to be faced with the same situation again. I do not know how much time will they take. Supplementary affidavit में they have referred to one judgment. Hardev Singh.
2 weeks.
And you tell us that it is a perpetual work. सफाई कर्मचारी आपको हमेशा चाहिए कि नहीं चाहिए?
I'll seek instruction.
No, you have to seek instructions specifically in connection with Hardev Singh's judgment also. If it is a perpetual work and you employ the persons on contract basis, don't create post and you exploit them. Why should it be like this?
Madam, the matter was remitted by the division bench only for the reason that there was no contract. In the last order by manager.
You see, in the rejoinder, they have given up their plea on the basis of the circular because they know that they are not covered by the circular. They have completely given up, right? Are you covered by the circular? Do you still insist that you are covered by the circular?
No.
They are not covered by the circular. They admit it.
And in Mallard's judgment to the last, it has come that Mallard has dealt with Nihal Singh's case. Whether if a person is working for a long duration or a non-sanctioned post, they can be considered working. That aspect has been taken care of.
Nihal Singh's.
Nihal Singh's case.
And this Hardev Singh है कौन सा केस है? धर्म.
धर्म सिंह and निहाल सिंह में भी है, नयन सिंह का पार्ट में भी है.
Nihal Singh. अच्छा, this case has already been taken care of.
Yes. And there is no finding by the appellate court that no finding with respect to the observation made in the judgment. Only limited on the ground that there was no finding. Now we have filed the counter appeal, we have taken this time. Now since the new factors come, I will have to see this.
The learned counsel for the respondent. Praise for and is granted. How much time do you need?
2 weeks.
2 weeks time to file a response to the supplementary count affidavit filed by the petitioner dated 2/2/2026. Post on 27.
No.
They have practically given up their relief on the basis of that circular. They do not say that they are otherwise concerned covered by that circular.
And
There are two orders that
Yes.
their case is to be considered on the basis of the
Yeah.
circular.
And there is a clear-cut finding in March order.
No,
that
we will
they-
not. We will not look into that. You see, we will not look into
No,
that.
no, since there
We
is
will
no,
revisit it.
there is no adverse finding.
Whatever.
My
See,
stand, I have taken
See,
a
a judgment which has been set aside and the matter has been remanded,
Right.
I will not look into that.
No, I have taken stand in my counter affidavit as well, that there were two earlier representatives, in those two representatives, there was a direction by the Honorable Court to consider them in the light of the request.
That's
That we have.
that scheme that you have prepared.
Yes,
And regularization was only with effect to the sanctioned post.
sanction. That
And
is
since
the
there are no
law.
sanctioned posts, therefore there is no question of regularization.
Regulation. On this ground only, we have been 23.
Are there certain orders passed by Honorable Supreme Court or even by our court that in spite of that circular, directions are being issued for regularization? Is that correct? To some extent.
I'll assist on that one also.
Because you see, we are concerned with one thing, that these Safai Karamcharis, they are working, right? And they put in 8 hours of work, correct? And then you keep them as contractual employee for their whole life, for their whole life, life in the sense, the valuable life.
In the age of superannuation.
Till they attain the age of superannuation.
Merely on the basis of 250 rupees per day.
So, does it not amount to exploitation? Does it not amount to exploitation? काम तो है and the problem is ये जो contractual employee के through employment होता है ना, जितना आप उनको देते हैं उतना उन तक पहुंचता भी नहीं. This is another hard reality of the society. We know that this is happening. In one Supreme Court's order also, there is an observation to this effect. पूरा पैसा भी नहीं जाता. So this is exploitation and it is against human dignity. A person who is regular employee, वो काम कर रहा है और एक contractual employee काम कर रहा है. हो सकता है contractual employee अपना contract बचाने के लिए ज़्यादा काम कर रहा है. Regular employee तो बोलेगा हमको तो disciplinary proceeding पर तभी हटाएगा. This is not.
Full knowledge of all this, they entered into the employment.
Yes, certainly they.
There was stipulation
Yes,
also.
yes, that's right. But their services were satisfactory with that is why you never remove them.
They are working continuously from 97.
25 years. 25 years you have taken work from them without any complaint. Right? लिखिए तो. The counter affidavit of the state should also indicate the supplementary counter of affidavit of the state should also indicate as to why an appropriate order in terms of the judgment passed by Honorable Supreme Court, which has been referred to in the supplementary affidavit, be passed considering the fact that the petitioners have been working for since 1997.
97, 92 maybe.
Since 1992/1997, continuously and without any complaint, and their requirement of work is of a permanent nature. The counter affidavit should also indicate as to whether this kind of treatment of the petitioners on daily wage basis at the rate of rupees 250 per day amounts to exploitation of the petitioners. इस पे सोच के आएंगे. आपको ज़्यादा समय, आप अच्छे से समझ के किसी हायर अथॉरिटी का आप एफिडेविट फाइल करेंगे. कौन फाइल करेंगे इसमें बताइए? Who is in a position to take a policy decision?
सेटलमेंट जैसा काम कितना इम्पोर्टेंट काम है, पर्चा लिखना, उसके तरमीम करना, सारा काम ही हो करता है वो।
सफाई कर्मचारी है कि
सफाई मोहरी मोहरी
वर्किंग एज
सफाई मोहरी
सफाई मोहरे.
मोहरी
It had also been indicated by the learned counsel for the petitioner that the nature of work being performed by the petitioners are of vital importance,
लैंड का सेटलमेंट
dealing with preparation of report with regard to settlement of land in the tribal area of Santhal Pargana. ठीक है. कल को मान लीजिए इनमें से कोई आदमी कुछ गलत कर दिया तो आपके पास क्या रेमेडी है?
सेटलमेंट का
See, every case is need not be opposed. If any of these persons commit some misconduct in the preparation of land records, or if he is caught taking bribe, आपके पास क्या रेमेडी है?
रेमेडी तो है।
क्या रेमेडी है?
अगर गलत एंट्री हो जाएगा तो करेक्शन तो उसका होता है।
नहीं, उसका क्या होगा? उसके अगेंस्ट में तो आप टर्मिनेशन के अलावा कुछ नहीं कर पाइएगा। उसके अलावा क्या कर पाइएगा? कोई डिसिप्लिनरी प्रोसीडिंग, उसको क्या फर्क पड़ता है? रोज 250 रुपये मिलता है, 250 रुपये मिलना बंद हो जाएगा। एंड these positions they become a den for earning illegal money. आप उनको पेमेंट ठीक से नहीं करेंगे तो ऑन द स्पॉट क्या होगा? ठीक है, दे आर रिक्वायर्ड परमानेंटली। ट्राइबल एरियाज में इनका परमानेंट पोस्ट होना चाहिए। कान भी
76 से सेटलमेंट चल रहा है संथाल प्रणाम में, अभी तक खत्म नहीं हुआ, इट इज कंटिन्यू हुआ, बहुत सारे डिस्ट्रिक्ट में स्टार्ट भी नहीं हुआ।
आप अपना आपको ज़्यादा टाइम दे देते हैं।
Yes.
By 13th March you file?
Yes.
Post on 20th March.
Ideally, the time of petition may not be disengaged.
बहुत सभी ऐसा इंटरिम ऑर्डर नहीं होना है।
ये तो
वो कहाँ करना है?
Item 6, undertaking for orders with effect, item 6, second appeal, 6069 of 2025.
20 मार्च।
20 मार्च।
आपको रिजॉइंडर फाइल करना हो तो कर लेंगे।
हाँ कर लेंगे।
Yes, petitioner. This is a defective petition.
Yes.
इसमें preemptory order था।
जो डिफेक्ट था वो क्लियर हो चुका है। आफ्टर दैट फर्दर शाम रिपोर्टिंग में कोर्ट किसका डिफेक्ट है तो दैट वुड बी रिक्वायर्ड
SA number 6069 of 2025. Counsel for the applicant prays for and is granted time till 13th of February to remove the surviving defects. Preemptory. If the defects are removed within time, post on 17th February under appropriate.
Item 7, second appeal, 9815 of 2025, filing number.
There were two IAs, one IA 226, I pray I did not press that same.
IA number 226 of 2026 is dismissed as not placed.
Yes, yes. As far as 702 is concerned, it's for ignoring the defect number, part of defect number 175. It says that it has to be sent down for correction, but I have indicated that in the memo of appeal filed before the court below, these respondents' addresses, respondent number 1, 30, 22, 13 and 23 left out. So I have already disclosed that in the memo of appeal, but due to wrong instructions, those addresses were not correct. So I have also prayed for allowing me to amend the correct address in the instant memo of appeal. So my twin prayers are before the Lordships in the instant IE. But you should kindly see paragraph 4 onwards.
702.
702.
Yes.
The defect number 175, it mentions the addresses of respondents 1, 30 to 32 in the incident are not mentioned in the decree. Thereafter, I have given a specific above in paragraph 5 that upon perusal of memorandum of appeal, so and so, which was the learned first, it was revealed that under bona fide mistake, the addresses of incident respondents, so and so, as arrayed in the were left out.
Did they participate?
They, no, not all had participated.
This 130 to 32?
One had participated.
30 to 32?
32, I have to, in the final degree proceedings, perhaps.
And where is the present address?
Present address I have disclosed at para 9. Accordingly, I have made a plain in para 10 as well.
And what about 1?
1 is correctly disclosed. That's not information. And as regards para 10, I have given also that Surya Devi address I have written under that all that I need to be corrected. That all has to be deleted because Surya Devi was 33. Respond to 33. It was mentioned as all. From 30 to 33, all residents of such and such. 30 to 31, 32 are residents of such and such place at Bhopal. And Surya Devi alone stands at another place, resident of another place. 33. So maybe made permitted to correct the address of the respondents 30 to 32 and delete the word all for as regards the respondent 33 instance.
IA number 702 of 2026. This petition has been filed for ignoring / removing defect number 175. The Learned Counsel has submitted that the defect is regarding address of respond number 1, 30 to 32, which does not appear in the decree passed by the Learned First Appellate Court. He has submitted that due to inadvertence, their address was not provided even in the memo of appeal, and therefore there is no mismatch between the decree and the memo of appeal. He submits that the present and correct address of respondent number 30 to 32 has been mentioned in paragraph 9 of the interlocutory application, and he may be permitted to make necessary correction in the memo of appeal, memo of second appeal. The address of respondent number 1 has been correctly mentioned according to the applicant. He has further submitted that the address of 30 to 33 was mentioned in the memo of appeal to be the same, and accordingly the term all, the word all, which has been mentioned in connection with the address of respondent number 33 be deleted, as the address of 30 to 32 is different from the address of respondent number 33. The Learned Counsel submits that in view of the aforesaid circumstances, the appellate decree is correct and there is no need to send the same to the concerned court for correction. Considering the aforesaid submissions and subject to any objection that may be raised by the respondents, and the records that will be received from the concerned court, the defect number 175 is hereby ignored. The counsel for the appellant is permitted to insert the address of respondent number 30 to 32 as mentioned in paragraph 9 of the interlocutory application, and also delete the word all as mentioned in the address portion with respect to respond number 33. The IA is accordingly disposed of.
I may be permitted to make correction because of this.
The counsel for the appellant is permitted to make out necessary corrections in cause title in red ink during the proceeding.
Which is the rate of delivery of possession and issue against a preliminary decree as
आज तो
second
नहीं हो
appeal.
सकता ना, आज तो
नहीं आज नहीं हम ये बोल रहे हैं कि second appeal arising against a preliminary decree is coming up for hearing on 11th section in the list. So can be come because there is a prayer for stay of the execution of both the appeals arising out of execution case.
This is final decree.
This is a final decree. So legislation by preliminary decree appeal is coming for hearing on 11th.
Under what heading?
Order for
Office is directed to place this case under appropriate heading on 11th. It has been submitted by the counsel for the appellant that the second appeal arising out of preliminary decree being SA number
29 of 2026.
SA number 29 of 2026 is scheduled to be posted on 11th.
11th.
इसमें एक और शो करा ये जो इग्नोरिंग ऑफ द डिफेक्ट 226 और
वो तो not pressed. Yes, आपका दो केस हो गया. What is your instruction?
पास ओवर केस आइटम 1
मंडे की जगह ट्यूसडे. आपके अभी ऑर्डर कौन लिया था? मंडे की जगह ट्यूसडे कर दीजिए. The receipt to be deposited by Monday. अच्छा एक बात बताइए. In civil litigation, cost clerk association को नहीं जाना चाहिए. Cost litigant को जाना चाहिए. So you have to give the cost to the litigants. है ना? Civil litigation में क्यों जाना चाहिए cost clerk association? लिटिगेंट का कोई कॉन्टैक्ट नंबर वगैरह है आपके पास तो उसका वो दे दीजिए. उसका बैंक डिटेल्स. ठीक है तो आप ऑर्डर में रहेगा तभी तो. ऐसा करिए डिपॉजिट इट बिफोर द रजिस्ट्री. उसका डिसबर्सल हम करेंगे. सिविल लिटिगेशन का कॉस्ट आपको लगता है लिटिगेंट को जाना चाहिए. वैसे बहुत परेशान है.
ट्यूसडे को 10:30.
हाँ 10. ट्यूसडे को कोई मैटर रखे हैं? 10:30 फर्स्ट केस.
Under heading for orders, item 8, CNP 318 of 2007.
वकालतनामा फाइल कर दिया.
But not one thing. So far I have OP number 17 Gita Devi states. But my instruction is not that see that issue is in the month of
July 24.
Yes.
Legal years का details. Legal years का details. अच्छा issueless. Her legal years are already on record.
No.
No, she died issueless.
From the July 20. Second thing that has come in the office note.
Who is OP number 7?
OP number 17.
17. Geeta Devi.
Gita.
GEETA.
GEETA.
This one?
From that in the office note, it has come that your OP number 10C, 14, 21, 35 and 38B, they have executed Vakalatnama with different names. My solution is they are one and the same person. I simply what is on the report we incorporate the name by making a list. I identified from their Aadhaar cards. If you are I will be allowed to not to.
You see, for this you have to file into
Otherwise, I am ready to file fresh from Vakalatnama.
You file fresh. That is better. Okay. fresh वकालतनामा. The learned counsel for the OP has submitted that OP number 17 named Geeta Devi has expired in the month of July 2024, issueless. He submits that. He also submits that some defect has been pointed out by the office with regard to wakalatnama. He undertakes to file fresh wakalatnama. ये पिटीशन तो आपको फाइल करना पड़ेगा ना डिलीशन का.
The same issue was there in Saksasotara, and that was decided thereafter. This
Geeta Devi died issueless has been disputed by you.
No, my lord, it was not. You are ventilated during the pendency of Saksasotara.
कोई बात नहीं, आप ये गीता देवी का कर दीजिए ना डिलीशन कर दीजिए. इसमें तो बहुत सिंपल है, इसमें कुछ करना ही नहीं है. ठीक है, इनका सबमिशन हम रिकॉर्ड कर ही दिए. ठीक है. You have received instructions from whom? On instructions from Ram Kinkar Jha, one of the opposite parties. Correct?
OP number 27.
On instructions from OP number 27. They belong to the same family. कब रखें बताइए सर. पिटीशन तो आपको फाइल करना पड़ेगा. डिलीशन का पिटीशन फाइल करना पड़ेगा. कब रख दें बताइए. आपको एक हफ्ता में हो जाएगा फ्रेश वकालत. 13 को रख दें, हो जाएगा ना. तारीख पे तारीख चलते रहे. पोस्ट ऑन 30.
Item 9, CMP 295 of 2008.
Dear Lordship, respondent number 4 and respondent number 6 illegally accused appear कर रहे Lordship. तो वकालतनामा मिला Lordship अभी फाइल नहीं की. प्लस सब्स्टिट्यूशन फाइल करने के लिए 2 वीक्स का टाइम चाहिए.
सब्स्टिट्यूशन
जी.
ये तो यहाँ सब्स्टिट्यूशन
नंबर
सब्स्टिट्यूशन हो चुका है. On respondent number, just
Respondent number
please
456 already appeared in this case. There is no need to file fresh wakalatnama. Wakalatnama has already filed on 9/6/2025.
4, 5 and 6.
Yes.
Right? आपको किसकी तरफ से फाइल करना
4, 6. Respondent number 4 and 6.
है. वकालतनामा तो ऑलरेडी फाइल है.
Lordship,
There is some confusion because 4 and 6 have been died, leaving behind 4 died, leaving behind 2 sons, Nirmal Munda, Vimal Munda, and 6 has been died, leaving behind 1 son, Shankar.
They have been substituted.
Yes.
कहाँ इसमें तो नहीं दिख रहा है सब्स्टिट्यूशन.
I have been filed a petition on pending substitution. 7/11/25.
आइए पेंडिंग है.
Yes.
इसमें नोटिस नहीं हुआ है.
Notice हुआ था.
तो आपको किसकी तरफ से वकालतनामा मिला है?
हमने फाइल किया था ये और फाइल रिस्पोंडेंट नंबर 5 उसमें दिया था कि 4 and 6 है.
तो आपको 4 and 6 के लीगल यूएस की तरफ से वकालतनामा मिल गया है.
Yes.
कहाँ है आपके पास वकालतनामा?
उसमें डाला हुआ है. 7/11/2025 को हमने फाइल किया था. उसमें एक पैराग्राफ भी हमने आइए भी फ्रेश वकालत
रिस्पोंडेंट नंबर 5 की तरफ से
Yes.
और रिस्पोंडेंट नंबर 4 and 6 का वकालतनामा
फाइव जो है वो आईए फाइल किए थे और उसमें एक स्टेटमेंट दिया गया था 4 and 6 के बारे में। 4, 6 का भी शायद है उसमें। मेरा जो वकालतनामा फाइल है।
This IA has been filed by the petitioners.
Petitioner number 5।
ये तो रिस्पोंडेंट नंबर 4 and 6 का डेथ हुआ।
हाँ, रिस्पोंडेंट नंबर 4 and 6।
हाँ।
एक आइए
4 and 6 के लीगल ईयर्स का वकालतनामा आपने फाइल किया है? दिखाइए जरा कौन से। दिखाइए कौन सा वकालतनामा। लीगल ईयर्स ऑफ रिस्पोंडेंट नंबर 4 and 4। आपको वकालतनामा किसने दिया?
जीवन गुंडा। अरे वो मांझी में पोस्टेड है सी ऑफिस का बड़ा।
कोई कॉन्फ्लिक्ट होगा तो लोग पर्सनली बुला लेंगे यहाँ से। दोनों में से कौन सा वकील आपको एंगेज करना है? यही उपाय है और हमारे पास कोई उपाय नहीं।
हाईकोर्ट आके दिए हैं।
कोई बात नहीं, कोर्ट में आके बताएंगे किसको एंगेज करना, अपना आइडेंटिटी कार्ड के साथ। नहीं है ना? तो फिर
रिस्पोंडेंट नंबर 5 का है जिन्होंने उनका
तो उनको मिला है
4 और 6 का डेथ सर्टिफिकेट उनको दिया था कि हमने सब।
कोई बात नहीं, उनको मिल गया ना वकालतनामा लेटर। आप रिस्पोंडेंट आपको कौन कौन वकालतनामा दिया मैडम?
देखिए बताइए, निर्मल मुंडा का कितना है, शंकर मुंडा का बोधन है, निर्मल है और बीरबल है। निर्मल बीरबल आप 3 लोग का है और शंकर मुंडा का भी दिया, सब लोग का है।
सबका हो गया? लिखिए नाम बताइए मैडम।
गंगा कुमारी
MS Ganga Kumari Kashyap submits that she has received wakalatnama on behalf of the legal heirs of deceased respondent number 4 and 6. आपको कोई ऑब्जेक्शन है सब्स्टिट्यूशन में? She submits that they have no objection so far as the prayer for substitution is concerned. आपको कोई ऑब्जेक्शन है? The learned counsel for the respondent number 5 has submitted that he also has no objection if the prayer for substitution is allowed. Considering the submissions, IA number 16404 of 25 seeking substitution of respondent number 4 and 6 is allowed. Counsel for the petitioner is directed to delete the name of respondent number 4 and 6 from the cause title and insert the name of their legal heirs and successors in reading during the course of the day. The wakalatnama should also be filed on behalf of the legal heirs of respondent number 4 and 6 should be filed during the course of the day. आप कर देंगे आज फाइल? आप बताइए क्या करना है? रिस्टोर कर दें? नेक्स्ट डेट में पहले वकालतनामा फाइल करें। Post on 30 in the supplementary cause list. 20th February in the supplementary cause list.
अगर इंटरमीडिएट को नहीं हुई तो 12th को हो सकता है।
अच्छा 12th को supplementary cause list.
Item 10, second appeal 524 of 2017.
second
Lordship, there are three IA petitions. One for IA, one IA is Lordship for the substitution of appellants.
IA number?
10286.
Just a minute.
Filed on
10286
2024.
24. Substitution of
The appellants.
appellants. Okay.
Appellant number 1 and appellant number 2.
1 and 2. Okay.
Thereafter, Lordship, application IA is 2543.
2543.
It is for limitation
of
2025.
For these two appellants, 1 and 2. For these two appellants, 1 and 2.
Yes, sir.
Limitation. And
thereafter, Lordship, one application IA is filed on 15148 of 2025.
148 or 25.
Yes.
This is for
15148.
15148.
2025.
This
This
is
is for the substitution of the appellant number 1, proposed appellant number 1. One successor has been died.
Okay. 1A 1B कौन मरे? 1A 1B कौन मरे? Proposed में से कौन से मरे?
1B.
1B नाम बताइए.
सुंदर मातो.
इनके legal years?
श्याम सुंदर मातो. 1A.
1A has expired. Okay. उनका legal years का नाम दिए हैं?
हाँ जी.
Okay. All right. Just a moment. 1 and 2 का respond number 1 and 2 का death कब हुआ था?
1 and 2 का डेथ हुआ है एक 8/7/2019. Appellant number 1 बालपन महतो. और appellant number 2 का डेथ हुआ है 20/12/2020.
और ये श्याम सुंदर का डेथ कब?
श्याम सुंदर का डेथ हुआ है died on 26/3/2025.
इतना डिले क्यों है? सब्स्टिट्यूशन में इतना डिले? काफी डिले.
Villages Lordship, therefore Lordship.
Drastic villages.
सबसे पहले तो फर्स्ट में कि उन लोगों को पता ही नहीं था कि केस पेंडिंग है and फाइल हुआ है. Thereafter when they came to know, then they filed a substitution petition. फर्स्ट में ही डिले हुआ, बाकी श्याम सुंदर यूज नहीं.
इसमें सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं बना है. अभी एडमिट ही नहीं हुआ है. ये तो बेचारे खुद अपीयर हो गए. अभी तो उनका अपीयरेंस का मौका ही नहीं है.
इनका केवल कंडक्ट दिखा रहे हैं कि ये कैसे करना चाह रहे हैं. इनका डेथ हुआ है इन द ईयर 2020, 19 and 20. इनका सब्स्टिट्यूशन ही फाइल करता है आफ्टर लैप्स ऑफ 5 years.
आप देखिए, just a moment. There was an IA which was filed.
The first IA, that is IA number 10286.
Yes. Seeking substitution of
1 and 2.
1 and 2. Yes.
That has been filed after lapse of 5 years. उसके बाद उसके बाद 200 that is limitation. और इनका जो limitation petition filed हुआ, so they are challenging the order of 2016 in the year 2017. And that time order was passed by this honorable court to remove author effect, including limitation petition also. This limitation petition is of delay of 228 days. They have filed this limitation petition after 7 years. उनका 228 दिन का जो डिले था, उसका लिमिटेशन पिटीशन फाइल करने के लिए इनको 7 दिन लग गए, 7 साल लग गए. And so far ignorance of pendency of this case is concerned, plus I filed the counter affidavit plus from since 1959. They are pursuing this case. All of their family members having full knowledge of the case. One of the complaint cases has also been stupid as it is because they have, by making a false document before the registrar, they have executed a past petition date. For that, a mutation case also been filed that has also been dismissed. And so far this order is concerned, this order of 2016 also attains its finality because after the death of the main respondent plus the subsequent legal heirs, who are the respondent number 1 and 2 in this present case, their name have been turned to the records of rights. अब इनका जो ऑर्डर हुआ म्यूटेशन का सारा कुछ हुआ, they have also challenged that order. The appearance before your lordship now proposed appeal plus they have challenged also that order. वो भी appeal उनका dismiss हो चुका. सारा नेक्चर जो लास्ट काउंटर affidavit जो फाइल किए सारा नेक्चर उसमें लगा. ये ऑर्डर जो अटेंस फाइनलिटी जब उनका नाम डिलीट हो गया रिकॉर्ड्स ऑफ राइट उनका नाम है ही नहीं. रेस्पोंडेंट नंबर 1 और 2 का नाम, उस ऑर्डर को उस म्यूटेशन को चैलेंज भी किए गए और वो चैलेंज होने के बाद डिसमिस भी हो गया. आफ्टर डिसमिसल दे हैव आल्सो प्रिफर्ड एन एप्लीकेशन बिफोर एडिशनल कमीशन राज्य.
वो तो डिसमिस हो जाएगा ना कि पुराना ऑर्डर ऑलरेडी है तो
ये सेकंड अपील इज नॉट मेंटेनेबल इटसेल्फ क्योंकि ये जो ऑर्डर है उस वक्त ये है ही नहीं क्योंकि इसका सब्सिक्वेंट जो रिपब्लिकेशन होना था इनके जो लीगल शेयर थे वो सक्सीड कर चुके हैं. अब उनको उस ऑर्डर को चैलेंज करना होगा जो उसका म्यूटेशन केस में जो ऑर्डर हो उसको चैलेंज करना.
जब ये ऑर्डर नहीं सेटिस्फाइड होगा तो कौन सा म्यूटेशन केस इनके फेवर में हो जाएगा?
वही तो बता रहे हो.
वो तो
मेरा
कभी नहीं
म्यूटेशन
होगा.
ऑलरेडी हो चुका है. मेरा म्यूटेशन ऑलरेडी हो चुका है बाय वे ऑफ लीगल हेयर्स. उस ऑर्डर को ऑलरेडी चैलेंज कर चुके हैं उसमें भी उनका डिसमिस हो चुका है.
क्योंकि when this or as long as this order is standing they will not get relief anywhere.
तो वही तो उनका कंडक्ट हम बताना चाह रहे हो जो कि अगर ऑर्डर में एक्सपर्टी है भी पास नो एक्सपर्टी नहीं है उसका अपीयरेंस पूरा है. एक्सपर्टी है एक्सपर्टी नहीं जो ऑर्डर हम पढ़ बता देंगे उसमें अपीयर करके दोनों अपीलेट कोर्ट में फर्स्ट अपीलेट कोर्ट में और फर्स्ट हर्ड they have appeared before the court. They have filed their reply
categorically that we have not heard
because वो परसू नहीं कर रहे थे वहाँ पे अपीयर करने के after appearance plus this presumed they have full knowledge of the case. वो अपीयर करने के बाद
What is IA number 4771 of 2024? 4771 of 2024. What is this IA?
They had filed for appearance.
वो allow चुका for appearance of this respondent number 1.
कहाँ है IA number?
There.
4
2022
हाँ.
8612.
कहाँ है? कहाँ है वो? कहाँ है वो?
86/2022 he has number I don't know.
IA number 4771 of 22 दीजिए जरा.
Yes. For appearance to come.
कहाँ है दीजिए? बहुत चाहिए. रिस्पॉन्ड नंबर अच्छा ये ओपी नंबर 1 है. One of the how many appellants are there?
Two appellants, Balpon appellant number 1 and 2. He died. Both of them died, and thereafter Lordship substitution petition has been filed. Still, it is pending. It is no order has been passed, and thereafter Lordship the legal heirs of appellant number 1 is 3, and legal heirs of appellant number 2 is 2. And if your Lordship allow me to read the orders which has been challenged before this court in second appeal.
Any suit pending?
No. Right, I don't have any instruction.
बस इनको तो इंस्ट्रक्शन मिला भी नहीं था, इनका क्लाइंट का डेथ हो गया, हम इनको बताया था सब्स्टिट्यूट।
ऐसा होता है ना एडवोकेट के पास
क्लाइंट दे दिया है मैडम के पास, डेट में भी मालूम से मेरी मन पर।
एक सेकंड, लिटिगेंट जानता है कि हाई कोर्ट में वर्षों तक केस नहीं होता, इसलिए नहीं आते वकील साहब।
आपको याद होगा कि इनके क्लाइंट आके पीछे बैठे हुए, जब कोर्ट को इन्फॉर्म किया तब से उनसे पूछे जाए जब नाम का डेथ।
इस तरह से हम लोग किसी क्लाइंट को आइडेंटिफाई नहीं करते हैं।
नहीं सर के बारे में 144 का
देखिए ऐसा है कि द मैटर हैज बीन पेंडिंग सिंस 2017, राइट, एंड 2017 के बाद सीधे ये वाला जो है ना केस पहली बार बेंच में लिस्ट हुआ है 2020 में, उसके पहले लिस्टिंग ही नहीं हुआ है इस केस का। नहीं, कोई और ऑर्डर है ही नहीं, पहला ऑर्डर है 29/6/2020.
Because the defect was not due.
Yes, that's right. So there was no occasion, na? Then what happened?
29/6/2020.
हाँ, 2020. उसके बाद ये सीधे 2025 में ये केस। तो भाई इसमें जो है ना लिटिगेंट का दोष नहीं हो सकता है। We will allow the substitution, right? We'll allow the substitution. Limitation पर आपको सुनेंगे। Here you want limitation का आपके
Limitation plus.
We'll see that.
But
Limitation
there
का
was a
contract.
specific order of 2020 itself, and the limitation petition was filed. अगर हम 2020 को भी जुर्म पैरामीटर मानते हैं, तो भी limitation petition after 5 years filed.
We'll see that. You have filed your response to limitation petition. लिखिए ऐसे नंबर 524 of 2017, IA number 10286 of 24 has been filed for substitution of appellant number 1 and 2, who are said to have expired on 8/7/2019 and 20/12/2020 respectively. Another IA being IA number 15148 of 25 has been filed seeking substitution, stating that the proposed legal heir of respond number of appellant number 1, that is 1 within bracket A, namely Shyam Sundar Mehto, has also expired on 26/3/2025, and the names of his legal heirs and successors have also been mentioned in the interlocutory application. The learned counsel for the you are seeking setting aside abatement also?
Yes, sir.
The learned counsel has also submitted that. A prayer has also been made for condonation of delay in filing the substitution application and also for setting aside abatement.
No, Mr. Abatement has been abatement. I think there is no prayer for abatement. First time was 1,086.
So for abatement is concerned.
There is no prayer.
So prayer may government
Just a minute. That's 5 thresholds.
हाँ sitting seat allotment and condone the delay है prayer है
अच्छा ठीक.
Prayer
Okay.
portion में.
The learned counsel for the respondents has vehemently opposed the prayer and has submitted that there is enormous delay in filing substitution petition. To this, the learned counsel for the appellant has submitted that the matter was listed for the first time in the bench on 29/6/2020, wherein the direction was issued to the registry to send the impugned order to the court concerned for removing defect number 1. And then the matter was listed for the first time, and then the matter was listed after a long gap on 5/8/2020. The learned counsel submits that Under such circumstances, the petition for substitution could not be filed. He has also submitted that valuable right of the appellant is involved in the present case, so the prayer for substitution be allowed. After hearing the learned counsel for the parties and considering the aforesaid fact that the matter has remained pending since 2017 and it was listed for the first time before the bench on 29/6/2020 for the aforesaid purpose, and thereafter it was listed only on 5/8/2025. This court is of the view that for the ends of justice, the prayer for substitution and condonation of delay in filing the substitution and setting aside appointment is allowed. The counsel for the appellant is directed to delete the name of respondent number 1 of appellant number 1 and 2 from the first title and insert the name of legal heirs and successors of appellant number 1 and also the proposed legal heir and successor of 1 with the bracket A, whose details have been mentioned in the IA number 10286 of 24 and IA number 15418 of 25 in writing during the course of within a period of 1 week.
Yes.
और अब आपका लिमिटेशन ये 5 साल का डिले बहुत खतरनाक है, आपको बता दें। इतना आसानी से इस डिले को नहीं
डेलिब्रेट तो नहीं होता है, न्यूज़ से होता है। ये पार्टीशन डीड फाइल के कंप्लेंट केस हम लोग फाइल किए, they have appeared, they have taken bail, they are making a false document, they have misled the registrar also.
अच्छा, उस आईए पे बात में सुनो। आपने रिप्लाई फाइल कर दिया? आप उसको रिजॉइंडर मानो तो फाइल कर देंगे। Technically, you are supposed to explain the delay till the date of filing of the limitation application. तो आप रिजॉइंडर में भी तो कुछ एक्सप्लेनेशन देंगे ना, कुछ तो करेंगे। क्योंकि यहाँ देखिए 2 डेट मटेरियल डेट आपको बता दी। एक तो 2017 के पहले तो ये केस लिस्ट में ही नहीं आया, 17 से डिफेक्टिव चल रहा था। द ऑर्डर ऑफ द कोर्ट वाज इटसेल्फ डिफेक्टिव, रिकॉर्ड किया, उसके बाद 2025 पे लिस्ट हुआ। आपको बता दिए क्या क्या ग्राउंड, सो आप अपना समझ के देख के ठीक है।
ये कह रहे हैं कि 2200 इतना दिन का डिले है, 525 days delays has been condoned by this honorable.
हम तो 6000 दिन का भी डिले कंडोन करते हैं, लेकिन there has to be some explanation, and explanation has to be there till the date of filing of the limitation.
During filing the rejoinder, I will file an explanation.
Post on 27th हो जाएगा, ठीक है। For hearing on IA number 2543 of 25 seeking condonation of delay in filing the second appeal, and it is all. In the meantime, it will be open to the appellant to file a response to file a rejoinder to the interlocutory application seeking condonation of delay. अल्टीमेटली होना यही है, जो सूट में होगा वही होगा और कुछ होने वाला नहीं।
बस होगा पे ही।
सूट कहाँ है और कहाँ चल रहा है? रिमांड बैक का बात नहीं है। अगर सूट फाइल हो गया है, who has filed the suit?
Well, it's some other person, not this.
Both of you are parties.
In that case, they are not.
You are the party.
I'm the. In the original Khatyan holder, they have filed the suit plus they are different persons. They are only making claim. They will not make a party.
They have supplied the in which our ancestor is the Khatyan holder. Their documents. I am not saying.
I will be explaining that.
We'll see that. It was a petition for rectification of record of rights.
Yes.
Was the appeal filed within time?
That appeal was filed within time.
And thereafter, just to delay them as
second appeal.
The suit was filed within time.
सूट के बारे में अभी फाइल एक मिनट
नहीं एक जो ये जो रेवेन्यू सूट है, रेवेन्यू सूट
जो फाइल हुआ था उसमें हम लोग अपोजिट पार्टी दे आर द पिटिशनर और उसमें हमारा अपीयर कर दिया, उसके बाद हमारा कोई अपीयरेंस मेरा तरफ से
जो अपीयरेंस एक मिनट
बोलने तो दीजिएगा।
क्वेश्चन ऑफ देयर मस्ट
इतना एंजाइटी थोड़ा सा समझने से अगला डेट में इजी होता है, इसीलिए
तो उसमें जो है हुजूर कि हम अपोजिट पार्टी थे, हमारा वकील अपीयर कर दिया था। अपीयरेंस के बाद फिर वकील मेरा अपीयरेंस दिया नहीं। वी आर द माने विलेजर्स, वी डोंट हैव दैट मच नॉलेज लॉर्डशिप। In that regard, ex parte order has been passed. Against that, we have appeared before the appellate court. अपील फाइल किए, हमारा कोई डॉक्यूमेंट नहीं लिया गया, राजा इन लोग फोर्ज डॉक्यूमेंट दिया, फोर्ज जिनोलॉजी दिया है। दिस इज द केस लॉर्डशिप। जिस दिन फाइनल हियरिंग होगा उस दिन सारा चीज आ जाएगा।
ये फोर्ज डॉक्यूमेंट है जो हम ट्राई कर।
एक सेकंड रुक जाइए। Considering the arguments and the allegation and counter allegation
No,
made.
we are not making allegations. I am not making
allegation and counter allegation.
No.
Okay. Considering the contours of the case as submitted by the learned counsel for the parties, let the records be called for from the concerned. हो जाएगा clear? अगर रिकॉर्ड आ गया और डिले कंडोन हो गया तो हम टाइम नहीं देंगे।
हम टाइम आज
87 का केस है।
हुजूर हम पूरा जजमेंट के साथ रेडी। आज ये बहस करें सर, बहस कर हम रेडी हैं।
ठीक।
Item 11 CMP 387 of 2018.
File 1IA for substitution of respondent number 6 rather than CMP.
Respondent number 6. It is arising out of a writ petition.
Yes. It was
When
dismissed.
did respondent number 6 die?
Basically, that certificate is an exam 1.
During the pendency of CMP.
During the pendency of CMP 150 arrangements, which was filed for restoration of the present CMP. Now 150 was restored by the order dated 19/12/2020.
It was dismissed on account of non-removal of offence. CMP number 387 of 2018. This petition, I am with IA number 971 of 2026. The interlocutory application has been filed for substitution of respondent number 6, who is said to have expired on 26/1/2023. The name of legal heirs and successors have been mentioned in paragraph 3 of the interlocutory application. Let notice be issued to the proposed legal heirs and successors of respondent number 6 through the concerned police station, for which requisites be filed within a period of 1 week. ये IA में भी फाइल करिएगा and main petition में भी फाइल, in IA as well as the main petition. Post on 13th March.
Whether the corrections in the petition has to be made?
Not now. We will allow the substitution once they are ready.
Item 12, second appeal 41 of 2022.
There could be many objections in substitution. I don't allow it. There could be an objection that all the legal heirs are not on record. There could be an objection that they are not the legal heirs. We do not. So that has to be taken care of. Yes, please.
Now, see, notice is being issued to the deceased respondent number 8. Office has pointed out that the notice of the proposed legal heirs of the deceased respondent number 8 of it appears to be delivered.
Essay number 41 of 2022. Counsel for the applicant submits that, as per the office note, the notice upon proposed legal years and successes of respondent number 8 appears to be delivered. The respondent number 8 has expired on 24/3/2025, and a petition for substitution has been filed, being IA number 16700 of 2025, with a petition for, with the 5 का अलग फाइल किए, अच्छा, with a prayer for condonation of delay and for setting aside abatement. Nobody has entered appearance on behalf of the proposed legal years on successors of respondent number 8. Considering the submissions, the prayer for substitution, the IA number 16700 of 25 is hereby allowed. The counsel for the appellant is directed to delete the name of respondent number 8 from the cause title and insert the name of his legal years and successors in red ink during the course of the day. ये admit नहीं हुआ अभी तक?
नहीं
तो उनको नोटिस क्यों हुआ था?
ये तक इसीलिए नोटिस हुआ।
अच्छा, इसीलिए मतलब अपने से ही आप फाइल करते हैं। Office is directed to place this case under appropriate heading. और कोई डिफेक्ट तो नहीं है?
नहीं, कोई डिफेक्ट नहीं। The plaintiff filed title suit to declare some right title interest and sale it executed in the year 1950 be declared invalid by law.
Under appropriate heading on 25th February.
Item 13, CMP 120 of 2022.
Pursuant to the order dated 9th January 2025, the notices were issued in the limitation matter as well as on the substitution matter of the sole of the party died. Pursuant to the service report, to come to the notice of the petitioners that the sole of the party died and therefore an application with a prayer for substitution.
Notice is served. Notice is served.
Notice as per the office note.
CMP number 120 of 2022. As per the office note, the notice upon opposite party number 1 within brackets 1 and 1 within bracket 2 to 1 within bracket 5 has been served either personally to opposite party number 1 within bracket 1 or through their mother. But nobody has entered appearance. IA number 2619 of 2022 seeking confirmation of delay of 346 days in filing this petition for restoration is allowed considering the amendments made in the interrogatory application. CMP 120 of 2022 has been filed for restoration of second appeal number 570 of 2015, which was dismissed for default on 1/4/2019 due to non-removal of defects in terms of order dated 25/3/2019. कोई रीजन दिए हैं?
डिफेक्ट में एक डिफेक्ट का लिमिटेशन पिटीशन ऑलरेडी फाइल कर चुके हैं लेकिन बाकी दो एक और सर्वाइविंग डिफेक्ट हम नहीं कर पाए.
The learned counsel submits that due to inadvertence, only some of the defects could be removed. Considering the aforesaid submissions and being satisfied with the cause shown, essay number, the time for removal of defect in essay number 570 of 2015 is extended till 27th of February. Preemptory रह गया sir. If the defect 27th हो जाएगा? If the और बढ़ा देते हैं. 20 तारीख 20 मार्च 20th of March 2026. If the defects are removed within the extended time, office is directed to place the second appeal before under appropriate heading on 24th of March. This CFP is accordingly disposed of.
Item 40, CMP 726 of 2027.
This CMP is filed for discussion of the second appeal 121 of 2019. And on this second appeal has been dismissed in default for non-prosecution.
Non-prosecution?
मतलब you asked the
for non-compliance. दोनों में क्या है?
Non-compliance.
Defect था matter.
Defect था उसमें कोरोना था वो मिला था फिजिकल जो फिजिकल हेयरिंग.
That's right. और टाइम बाद है.
हाँ उसके बाद था कि उन्हें 30 डेज का देना था. लेकिन वो
आईए में नोटिस हुआ है.
हाँ नोटिस हुआ. लेकिन वो आया नहीं. तो गलत हो गया.
किए हैं. लिखिए. और तो कोई नहीं है. 3 ही ऑपोजिट पार्टी है ना.
हाँ.
4 है.
4.
चौथा नहीं 4
ये 4 है. ये 4 पिटिशनर
और 4 पिटिशनर. ओ ठीक है. लिखिए. CMP number 726 of 2020 with IA number 11010 of 2022. The counsel for the appellant submits that the service of notice is complete inasmuch as OP number 2 and 3 have appeared through Wakalatnama and OP number 1 has been served through his son. The learned counsel submits that the IA has been filed seeking condonation of delay in filing the CMP. He has submitted that due to inadvertence, the learned counsel submits that the case was being conducted by another counsel, but for some reason or the other, the previous counsel did not remove the defects, and ultimately the second appeal got dismissed on account of non-removal of defects. And consequently, there has been some delay in filing the prayer petition for restoration. After going through the prayer going through the averments made in the interlocutory application, the prayer for condonation of delay in filing this CMP is hereby condoned. CMP number 726 of 2022. This petition has been filed for restoration of second appeal number 141 of 2018, which stood dismissed on account of non-removal of defects in terms of order dated 10/9/2020. The learned counsel submits that the defects could not be removed within time, although there was no intentional lapses on the part of the petitioner, and there was being satisfied with the cause shown, the time for removal of defect of second appeal number 141 of 2018 is extended till 27th of February. Synopsis technical होता है 13th of March. If the defects in the second appeal is removed within the extended time, post this case under appropriate heading on 18th of March. 16th of March. If the defects are removed within the extended time, post this case under appropriate heading on 25th of March. मेरा तो सबसे लकी दिन ही 13th है. 13th is a very lucky day for me.
अच्छा तो ये बर्थडे है?
Not my birthday. Birthday का luck से कोई लेना देना नहीं.
Item 15, CBDB 104 of 2023.
The order dated 11/7/2025. This were issued upon the final respondent 4/9. As per the service report, notice was issued on 4/9. 4/5 have appeared to Alaknama. Respondent number 6 not served, reported by Sushil Ram that she residing with her daughter at her house. That is, the details of her residence is not known to him. 7, 8, and 9 had died. Regarding the respondent
7, 8, and 9.
8 had died on 29/5/2020, that is prior to the order passed.
So, what do you have to say?
We file an IA regarding the support substitution of respondent number 7 and 9. Regarding 8, we file an IA seeking leave of this.
Civil review number 104 of 2023. Respondent number 7, 8, and 9 have been reported dead. Respondent number 8 has expired on 29/5/2020 prior to filing of the civil review application. Respondent number 6 could not be served as she is residing with her daughter at a different address. Counsel for the petitioner prays for time to take appropriate steps. कब रखेंगे time?
Next, 20th.
Post on 28 January, February.
Item 16, first appeal 134 of 2024.
Notices were issued upon the substituted legal heirs of respondent number 8. Service report has said respondent number 8A it is in transit. 8B it has delivered on 7/1/2026.
Senior counsel
कौन है आपके सीनियर काउंसिल? FA number 134 of 24. Notice in view of the office note. Notice upon proposed respond number 8 in bracket B is accepted as validly served. Eight A B सगे भाई हैं क्या दोनों?
Both are illegal here. Yes.
The learned counsel for the appellant has submitted that कौन सा आईए नंबर है?
IA number 16597 of 2025. Is residing in which both of them are at different addresses.
The learned counsel for the appellant prays for and is granted 1 week time to take fresh steps for service of notice upon respond number 8 within bracket 8 कहाँ रहते हैं?
He is residing Rachini
Through the concerned police station, for which requisites be filed within 1 week. Post on 13th March.
Item 17, CIP 154 of 2024.
In this case, there are three ID malware. Notice has already issued malware.
3 IA for what?
2 IA malware, IA number 3356 of 2025 for substitution.
Notice is complete. Service of notice is complete.
Malware. And another IA malware 82781, also substitution petition malware. And third IA malware, IA number 8807 of 2025, limitation petition.
एक तो डेथ हो गया है, उसी का सब्सक्रिप्शन
दो तो आई है, एक है ड्यूरिंग डिपेंडेंसी ऑफ द सेकंड अपील रेस्पोंडेंट नंबर 14 जो है टुकलाल नायक का डेथ हुआ, उसका आईए फाइल किए हैं, वो उसमें स्टेटमेंट दे दिए थे सीएम ने पैराग्राफ 8 में कि ये ड्यूरिंग डिपेंडेंसी ऑफ द सेकंड अपील गाइड कर रहे हैं, इसलिए पार्टी नहीं बना रही. So that after that stamp report, I filed the IA petition for substituting the legal years of Tuklal Naik. This is number 14 in second appeal.
Respondent number 13 का 17 का legal years, they all refused. सेवेंटीन तो सब रिफ्यूज कर गए और 36 AD delivered to Kherabo. Who is she, Kherabo? Yes. And 32 के legal years. Who is Kherabo? ये वाला तो खैरा बो को सर्व हुआ है 36A to 36D. Who is खैरा बो? हाँ? वो वन ऑफ द लीगल ईयर्स तो नहीं है ना, तो उसके लिए तो आपको फ्रेश स्टेप लेना पड़ेगा. उसके लिए आपको फ्रेश स्टेप लेना पड़ेगा. CMP नंबर 154 of 2024. As per the office report, the notice upon 36A to 36D has been shown to be delivered to one person, namely Khaira Bo. The notice cannot be accepted as validly served. Counsel for the petitioner is directed to take fresh steps for service of notice. On IA number 8278 of 2025. To therefore state proposed legal years and successors of OP number 2036 through the concerned police station. The requisites for service of notice be filed within a period of 1 week. एड्रेस कहाँ पर?
अभी ये कहाँ रहते हैं पूछना होगा ना.
कोई तो ऐसा तो नहीं आया है रिपोर्ट कि वो नहीं रहते हैं वहाँ पर.
कौन लिया वो तो उसके लिए बुलाना होगा.
कौन लिया से कोई मतलब नहीं. ठीक है. By 20th, 20 फरवरी. Post on 24th April.
Item 18 CMP 300 of 2023.
IFIT expense giving effect number 5 also.
CMP number 300 of 2024. IA number
16383.
16383 of 25 has been filed, seeking extension of time for removing the defects.
Defect number only 5 also. All defects have been removed.
For removing the defect number 5.
Order dated 27.
ये यहाँ कैसे आ गया? मतलब ये तो already the order has taken its effect.
Before expiring this order.
तो क्या हुआ? You have to get it extended. हम इस तरह से नहीं करते.
इस बार किया जाए. इस बार maybe before expiry of the order.
आप proper CMP नहीं. ये extension हम नहीं देंगे.
एक सप्ताह देंगे हम तुरंत.
एक दिन भी नहीं दे सकते हैं. ऑर्डर ये तो केस लिस्ट में आना ही नहीं चाहिए था. ये आ कैसे गया हमारे लिए ये आश्चर्य का बात है. ऑर्डर हैज टेकन इट्स इफेक्ट. हम नहीं करेंगे. आप सेम बेंच से करेंगे. CMP number 300 of 2024. The petition IA number 16383 of 25 has been filed, seeking extension of time. With respect to order dated 27/11/2025. Office is directed to place this case before the appropriate bench who has passed the order dated 27/11/20. वहीं पे चाहिए भाई. और ये CMP का ये मेरे पास क्यों आ रहा है? ये तो उन्हीं के पास आना चाहिए. किसके ऑर्डर से ये DSD हुआ? उन्हीं का ऑर्डर है ना. Whose order was that?
Honorable Mr. Justice Amitabh Kumar.
वहीं से करेंगे. As the assigned matter होगा ना, why is it listed over here? ये तो मैटर फिर राजेश शंकर के साहब के पास लिस्ट हुआ था. एक जब कोऑर्डिनेट बेंच किया मैटर लिस्ट हो गया, तो अब यहाँ पर वहाँ पे एक प्रीएम्प्टरी ऑर्डर होगा. अब प्रीएम्प्टरी ऑर्डर का पीरियड एक्सपायर कर गया, अब हम यहाँ से एक्सटेंड करें. Right. The order dated 27/11/2025. The preemptory order dated 27/11/2025, by which time was granted to remove the defects, has already expired. नहीं से करें.
Item 19, CMP 627 of 2024.
That the notices have been validly served. 3A she has received by herself and 3B notices was received by 3A. And so far as the opposite party number 5 is concerned, the person is dying without having no legal heirs and successors. So in this regard, I will be requiring some time to file a real publication of the name of this party.
CNP number 627 of 24, the counsel for the petitioner seeks adjournment. Post on 20th March.
Item 20, CMP 672 of 2024.
CMP for restoration of trust for non-compliance of order dated 16 December 2025. For combination of delay notice
IA number 6901 of 24 and CMP number 672 of 2024. Issue notice to the sole respondent. Through the concerned police station. Through speed post, for which recusals be filed within a period of 1 week. State bankrupt हो गया है. क्या चीज़ है? हाँ?
कम्युनिकेट करना पड़ता है भगवान का सेवा.
क्या कम्युनिकेट? नोटिस के लिए भी कम्युनिकेट करना पड़ता है. वो आएंगे तब आप नोटिस फाइल करिएगा. I just want to know. State will file the requisites for notice only when this secretary road construction department will come to you. Preemptory order. Post on 13th. Speed post का notice IA में file करिए. नहीं देंगे.
Item 21, CMP 898 of 2024.
CMP is for restoration of the second appeal in 2043 of the which is instead of a non-prosecution by order marking the notices have been served by order dated 22 December.
डिवाइन वर्क क्या है आपका?
Divine, sorry, not R is missing in that driving job. Driving job. R has been missing.
ड्राइविंग जॉब.
Driving job. ट्रक का ड्राइवर है वो, ट्रक चला रहा है.
मुझसे चाहिए डिवाइन है.
नहीं डिवाइन है वो, तो उसमें वो इसमें R मिसिंग हो गया वर्ड. डिवाइन.
इतना डिले है.
दोनों पार्टी कॉम्प्रोमाइज कर लिए थे. हम जमीन खरीदे हैं, हम खरीदे हैं रेस्पोंडेंट से जमीन, और स्पेसिफिक परफॉर्मेंस एक्ट में ये हमसे कह रही है कि उसको हमको वापस कर दी जाए 5 साल के अंदर. और एक एग्रीमेंट दिखा रही है जो कि रजिस्टर्ड भी नहीं है, नोटराइज भी नहीं है, उस पर भी ऑर्डर हुआ.
तो सेकेंड अपील को क्यों डिसमिस करा दिए हैं? हाँ, 2009 का सेकेंड अपील है.
जो पैरा 2 में हम अपना ग्राउंड लिखे हैं.
क्या ग्राउंड लिखे हैं?
I was not present in the court because of my.
क्या कह के डिसमिस हुआ है? नॉन अपील के चलते.
नॉन प्रोसीजर.
Where is the order?
Look here, page 6.
Page 6 तो इसमें है ही नहीं. दिखाई जरा पेज 6 कहाँ पर? This is first appeal.
Second appeal.
You say that the respondent has compromised the dispute with the appellant out of court.
हाँ, इनके साथ कॉम्प्रोमाइज कर लिए थे. फिर जब कोर्ट का डिसमिसल ऑर्डर दिया वो भी हम लिखे हुए आईए में 11 कोर्ट का ऑर्डर 11/11/2023 को गया है. 25/5/24 को ये रेस्पोंडेंट हमको दिखाई है, तो फिर 28 से 24 को हम आ गए हैं आपके
IE number 7811 of 24. Issue notice to the respondents.
नोटिस इशू हुआ है प्रधान मैनेजमेंट काउंसिल के.
सर.
हाँ यस. कॉल लिस्ट में भी उनका नाम है. यस फाइल वगैरह तमाम सुना.
सेकेंड हाफ में उनको बुला के लेके चलो.
My car broke down. I was not able to come.
Which
my
car?
personal appearance maybe I was not appearing. I not appearing.
It will be there. It's okay. I'm not passing here for sorry.
Your Lordship is another request.
we can't, you see, this is all live proceedings, recorded proceedings, we can't modify the order like this.